Okay, great. So, hi, everybody. Thank you so much for, number one, taking the time to register for this and taking time out of your day to attend this session. This first one in our fundamental series is At Will Ain't a Free Pass. Understanding why at will can cause termination risk. So I have this set up for 45 minutes. This is going to be pretty quick, but hopefully we will have some time to interact with one another if time allows. So let's go ahead and get started. So I believe I know most of you in the session, but for those of you that I have not met, here's just a couple things about myself. I have been in HR for a little over 25 years. You name it, I've pretty much done it. I did go to Wake Forest Law School. I have served as an expert witness in legal cases. And if you ever get an opportunity to do that, I highly recommend it. It was a fascinating experience. Both times that I did it, I loved it. I have done some consulting work and some investigative work, and I am currently the VP of Human Resources with Innovate HR. So that is enough about me. That's not why you're here. I know you were just dying to hear all about this at-will employment. So let's get started with that. So our agenda today, very short, very to the point. We are going to have a short welcome and introduction and at-will 101. What the heck does it actually mean? And documentation. I'm an HR person. You know, we're going to talk about that. And then we're going to end with some real talk. So I have some risky scenarios that we're going to talk through and try to give you an idea of what it actually looks like. And then we're going to end with some QA, and I have a couple of takeaways for you. So let's go ahead and get started. So welcome, everybody. I do have a kickoff question here. So I have a question that I would like to move on to the next slide here. We're going to begin with some statistics that I think are pretty interesting. So did you know that over 70% of U.S. workers are actually employed at will? So that's a big population. It's not that strange of a thing. So chances the reason you're on this call or this session is because you are too in an at-will state. Number two here, retaliation is the number one most common charge filed with the EEOC. They actually made up over 56% of all claims in 2023. And only 18% of employers say their managers are fully trained on what at-will employment actually means. So kudos to everybody in this session, because after this is over, you're going to be part of a population that has a vast understanding of what all this means. So congratulations on it. But wait, there's more. I've got some more fun statistics here. So a terminated employee is 3 times more likely to file a lawsuit if, wait for it, no explanation is given, or if there's not proper documentation that's been given or shown to that individual. Number 2, 1 in 4 wrongful termination lawsuits stem from perceived retaliation, even in these at-will states. This one is a fun one. The average cost, I love these, the average cost to defend a wrongful termination claim.
I was saying $100,000.
Good guess. I feel like you might have looked at my notes.
No?
All right, look at that. Even when the employer wins, Julie, you were right there, between $75,000 and $125,000. So keep in mind, that's not the most, it's not the least, but that's the average. So good job, Julie. I'll send you a gift.
Thank you.
All right. You're very welcome. Okay, and my last fun fact here, 59% of employers have lost wrongful termination cases due to, drum roll please, inconsistent application of policies or lack of documentation. So I like to begin these just with facts. I find this all very interesting. So let's go ahead and get down to what the heck does at will actually mean. So Kirsten, you nailed it. You got the answer right. It means employees can be terminated at any time for any reason or for no reason. So for whatever reason, that is theoretically what at-will employment means. However, we have a big but here. and this is what this whole presentation is going to talk about, there are some exceptions that can override an at-will status. So we're going to talk about contracts and offer letters, what you should and should not say in these, implied promises and inconsistent policies. Those don't exist, right? And then last, definitely not least, discrimination and retaliation laws. So we're going to begin our learning with some statements that should not be used in contracts or offer letters. So this, like I said, this is going to be very practical. So my very first statement that you see out there that should not be in any of these documents is, we are excited to offer you a permanent position with our company. That sounds so positive, right? Why is this risky? This may imply job security or a guarantee of continued employment. My second statement here that we want to avoid, we are committed to your long and successful future here. That just to me sounds so supportive and warm, but here's why it could get you in trouble. This could be used to argue that the employee was led to believe they wouldn't be terminated without cause. My third one here, and this one, I feel like I see this quite often. After 90 days, your position will be permanent. Problem with this one is that it implies could be interpreted as a probationary period that leads to guaranteed employment, which again contradicts the whole premise of what at will actually means. Number 4, termination requires progressive discipline. Again, if this is not a universally applied situation, it could lead to inconsistency. But it also, the employee could claim a breach of contract if this is something that is listed in a contract or an offer letter. And then we've got number 5 here. In the event of termination, severance will be paid unless the employee is terminated for cause. Again, suggests that the employment is cause-based and not considered at will. And then my last statement here is actually not a statement, but more of just the absence of a statement. So not having it stated that it is an at-will employment relationship. So why is this risky? If an offer letter or a contract lacks any mention at all of an at-will status, it could be harder to prove that both parties understood this at-will relationship, meaning that the employer and the employee, if it's not stated somewhere, they could argue, hey, we didn't know that it was an at-will state. So what is some good language? This is not going to surprise anybody. It's very basic. It's very to the point. Your employment with, we'll say, Innovate HR is at will, which means that either of you or the company may terminate the employment relationship at any time with or without cause or notice. This is basically what Kirsten said, right? So this is, again, very simple to the point. This one statement could keep you out of a lot of trouble. So next we are going to talk about some implied promises and inconsistent policies. So I have 4 examples of language that should not be included in employee handbooks or policies. And what I've done with each one of these statements is I've highlighted the risky language in red. So this is the first one. Employees will not be terminated without first receiving coaching or progressive discipline. That's the part in red is what could get you in some trouble down the road. Will not be terminated. So what that means is I think it's great to have it spelled out in handbooks and documents that there is a progressive discipline policy. But if you have that statement, will not be terminated, and you don't follow that, that could get you into a lot of trouble. Next up, we believe in job security and treating our employees like family. I love that. It sounds so warm and fuzzy, but that is giving an implied idea that there is a guaranteed job security. We want our employees to feel like there's job security. We absolutely want it to be a family-like environment. But at the end of the day, this is a business and you are in an at-will environment, meaning that you don't want to give that indication that there is a job security. Your position is guaranteed unless you violate company policy. That's pretty basic. That I think everybody on here would agree that that is pretty common sense, but the is guaranteed is the language that's going to get you into trouble. Employees who meet performance expectations will enjoy continued employment. Again, that goes against everything that at will stands for, right? And now, just because you don't have something in writing doesn't mean you're out of the woods. So there are some verbal statements, especially from leadership, that should never be said because it could give, again, that implied idea that employment is not at will. You'll always have a place here. Don't worry, your job is safe. I actually hear that quite often. Again, meant to be reassuring, but could backfire down the road. We never let people go without a warning. And just do your job and you'll never get fired. Last but not least, we only terminate when absolutely necessary. So let's talk about some best practices here. Always include clear at-will language in your offer letters, your handbooks, your onboarding materials. Reinforce policies like progressive discipline are guidelines and not guarantees. And sometimes in these policies and handbooks, one little tiny word from is to may could change the whole flow of the sentence. So instead of saying it's a guarantee, add language in there that is just a guideline, but not a promise, right? And then train managers to avoid making job security promises or overly reassuring statements. I think most of us are very caring and compassionate people, and we want to have our employees feel good, but it could backfire down the road. So there's a good balance of how to be that supportive and reassuring supervisor and leader without getting your company into trouble. So it's a good idea to periodically review your onboarding packet, website language, onboarding platforms, as well as the language in your performance reviews, handbooks, all that stuff. Just periodically take a look at it and just make sure you don't have any risky language. So I imagine that's what most of you are going to do when this is over, right? So now let's talk about a quick review on discrimination laws. That could be a presentation all in itself. And it seems pretty common sense, but it's not always. Oftentimes, things are said very unintentionally that could be perceived as discrimination. So I'm going to throw up a couple of sentences up here that could fall into something that might get you into trouble. First one, we need fresher energy. That could be perceived as age discrimination if you were to act upon that. You use too much sick time. I think we've all been through enough FMLA training courses that we kind of know to stay away from that, but you still hear it from time to time. This role might be too demanding. That could get you into trouble for gender or pregnancy discrimination. Your English is very well considering you're from whatever country. And last but not least, that outfit doesn't align with our dress code. Now, that can get a little tricky. I know that some organizations have look policies and dress codes, but you definitely have to have some flexibility built in there for religious accommodation. So we could put a pin in that. If you have questions about that later or want to get me offline, we can definitely dive into that. But definitely something that you want to be aware of. Now let's talk about retaliation. So remember back when I said that was one of the leading causes for unlawful termination lawsuits? So it seems common sense, right? It seems like we should know what retaliation is because, I mean, it's not like a manager is going to look at an employee and say directly to them, hey, I'm going to do this super negative thing to you because I intentionally want to retaliate against you. That never happens, right? Or it shouldn't happen. It does not happen. No. Oftentimes, these actions, real similar to the statements that could be perceived as discrimination, it is very subtle, but it's important to kind of have an idea of what actions should be scrutinized through the lens of perceived retaliation. So I'm going to put some stuff up here for you to look over. Retaliation could look like increased scrutiny or negative evaluations after a complaint or after an employee takes a protected leave. Exclusion, so excluding an individual from meetings, projects, or big decision making. Reassignment to less desirable shifts or duties without having a good business justification. Delays or denials of promotions, raises, or accommodations. The sudden termination following a protected action. So an employee reporting harassment or taking a FMLA leave or going on an accommodation, something like that. And then inconsistent discipline compared to other employees for similar behavior. So listen, when you're in doubt, always, number one, consult with your friendly HR professional. But also take a second look and ask yourself how an action could be perceived by an employee. So you do have to factor in recent actions or requests by the employee, because that's what retaliation is you're doing something because of, right? But take into consideration what's recently happened with that employee, then pretend like you're that employee. Put yourself in your shoes and ask yourself, is this being done to me because ... So then when you call me up and you say, I want to do this thing to this employee, I'm going to ask you a series of questions. That's my job. And I'm doing it. It's not because I'm being nosy or I'm trying to catch you in something. I'm just ensuring that this decision of what you want to do isn't going to come back and bite us in the rear end later on down the road. And here is some retaliation examples. So I've got some language that I'm going to put up here that I call it my HR spidey senses can perk up. So these could be red flags. These statements could cause me to do a little bit more digging and ask you a couple more questions before you make an adverse action decision against an employee. Ever since they complained to HR, they have been a big old problem. We need to keep an eye on her now that she's stirring things up. Let's document him heavily. He's becoming a legal risk. Now that sounds contradictory, right? Because I've been telling you, and you hear me say all the time, have you documented it? Where's the documentation? Let's talk about the documentation. However, if you are doing that to one individual and you're not doing it to others, and you're doing it to that individual because you fear something, that could backfire in your face if you're not doing it universally for everybody, or if you were not keeping good documentation beforehand. So definitely consistency is key. You'll never get in trouble if you're always being consistent. He took FMLA again. We need someone that can actually count on. We need somebody to show up to work. I'm not going to promote someone who makes HR complaints. There's some common misconceptions that hopefully we are now no longer going to have. We don't need a reason, it's at will. I think that's a pretty common sense one. We're safe as long as we don't say anything discriminatory. Again, that can happen very unintentionally, and no documentation is needed if they're underperforming. Believe it or not, I've had that argument presented to me, and my first comment back is, how do you prove that? Show me how you're going to prove that that person was underperforming. Documentation is going to save you every time. So we've talked about when my spidey senses are alerted and when I might probe and ask a couple more questions. But here are some very practical scenarios that I put up here that you as a leader should take a minute and pause before making any sort of adverse action. So let's talk about each one of these. The first one here, the employee recently filed a complaint or concern. So again, if it's a harassment, a discrimination, unsafe conditions, wage or hours, so any sort of complaint, no matter how unwarranted you think it is, no matter how ridiculous you may think it is, always ask yourself, could this appear to be retaliation? This next one, the employee recently requested or used FMLA or ADA accommodations or workers' compensation. Ask yourself, Have we documented a non-retaliatory business reason? There is little to no documentation of prior performance issues. Ask yourself, is this going to stand up to outside scrutiny? When I ask you these questions, is this going to stand up? Other employees in similar situations were treated differently. Ask yourself, are we being consistent with these actions? And the termination reason has shifted over time or it isn't clear. Ask yourself, what is the reason? And it can't just be you're tired of Joe over here or you're just sick of him. It has to be an actual reason and it needs to be backed by facts. All right, I have a couple more up here. The employee is in a legally protected class. Examples. There are a ton of these and they're not all listed up here. But did you know that if you were over the age of 40, you're in a protected class? Disability, pregnancy, race, religion, there's a ton of them, but always ask yourself, could this termination be perceived as discrimination? The decision is being rushed after an emotional conflict. Ask yourself, are we making a reactive or well-reasoned decision? There's an open investigation involving an employee. Big no-no. I can't imagine any instance where we're going to say, yep, let's let that person go. Will terminating them interfere with due process? Due process is very important. So have patience. Let the process work it out before you make these types of decisions. The employee has long tenure or prior positive evaluations. Will the documentation justify this shift in action? And I may have had this conversation with some of you, or I know that I've had it in the past at previous places of employment, but a supervisor comes forward and says, Joe over here is he's terrible. He's doing a terrible job. I want to let him go. I'm sick of him. I want to let him go. First thing I'm going to ask for, because I'm your good HR person, is all right, great. Let's review the documentation and just make sure that we've got a good timeline here to represent this poor performance. You look at those evaluations, and Joe is like a stellar employee. He looks fantastic. And I'm going to say, this probably isn't going to work well for you. So just keep in mind, be very accurate on these performance reviews. If somebody's not performing well, you need to document it. And last but definitely not least, HR hasn't reviewed the situation. Make sure and ask the question. 9 times out of 10, you're going to be fine, but we are going to ask these questions just to make sure that you're okay. At the end of the day, anytime you take an adverse action, anytime you terminate, it should not be done quickly, should not be done in haste. Take your time, take a breather. I know sometimes supervisors, they want to resolve issues promptly and move on. And I totally get it. I'm a supervisor too. I know how one bad apple can impact an entire team. So I get it. However, taking a pause, it might just save you from a very lengthy and costly legal battle that really you don't have time for. So just take a minute, take a breather. That's going to be one of the first things that I'm going to recommend when you call me up real frustrated is, okay, let's take a second and talk through this. So documentation, this is an HR person's dream, right? We have a couple pointers here. Why does it matter? Listen, it's not just for HR. Documentation, it's a protective measure for you and your company. Good documentation, it should tell a story. So there should be clear performance evaluations, which we just talked about, prior feedback or warnings. It could be as informal as an email that you sent. So anything that is a documented performance expectation, make sure that you've got that documented. And then reason for termination tied to business impact. So these first 2 bullet points are pretty basic. This last one can sometimes get you. Sometimes terminations are not due to poor performance, and they're actually just a financial business decision. It happens all the time. I get it. That is fine. But make sure you have documentation to support why you chose to let sweet old Bob, who's been with the company for 30 years, why you decided to let him go over Ted, who is the newer, younger, fresher employee. If you don't have good documentation as to why you chose that person over this person, that action in that example could actually lead to like an age discrimination case. So definitely make sure that even if it's for financial reasons, that you've got good documentation as to why one person was chosen over another. And bad documentation, no documentation equals a liability. Okay, so tips for smart terminations. These are very simple, make it actionable. This is very easy. Ask yourself, is there documentation? Is the timing problematic? Did something just happen with this employee, right? Did they just come back from FMLA? Did they just make a complaint to their manager about concerns about their compensation? And number 3, could this be viewed as discrimination or retaliation? And again, don't expect you to be an expert in all of this. Give us a call. Give your coordinator a call. Give me a call if you want to talk through any of these things. It's better to be ahead of it than to have to react to it later. So now we have got, all right, 10:30. So we have got 15 minutes. I have some scenarios that I want to go through with you. And anybody who's done any kind of training with me knows I love scenarios. I just think you learn a lot from them, kind of talking through what things actually look like. So what we're going to do is go through some of these like real world inspired. I didn't copy any situations that I've actually gone through. There's actually enough I could kind of mesh them together. But we are going to talk through the first one. So as I read each scenario, this is a lot of words up there, but I want you to be able to see them and read it either at your own pace or as I'm reading it. I want you to look for some red flags in each scenario and note the items that you think might be problematic or suspicious. And then at the end of each scenario, I'm going to show you some red flags and what problem those red flags could cause. So let's begin here. So we have Jasmine. Our company that we're going to stick with is ABC Company. Very creative, right? A long-term employee with ABC has recently been transitioned into a role reporting to a new supervisor, Bonnie. Jasmine has been with the company for over 25 years and has been an excellent employee. After a few weeks, Bonnie writes Jasmine up for not participating in team activities, and she tells Jasmine that she expects fresh ideas from her team members, and Jasmine seems to be the only one that just doesn't get it. Bonnie has a feeling that Jasmine is just too old school to complete the ideal team dynamic that Bonnie so badly wants to achieve. Since they all work at an at-will state, Bonnie wants to let Jasmine go ASAP before Jasmine brings the team down. So, does anybody see any red flag? Anybody want?
Good morning.
Morning.
One of the things that pops out to me is the fact that she's been an excellent employee, but she's written up for not participating in team activities. I would want to know what happened before the write-up. Was there any progressive discipline? Was there any type of performance assessment, any documentation of her participating in this type of behavior before?
Absolutely. You get an HR gold star. That is a fantastic analysis. There are definitely some red flags that are blaring out. So on top of just performance, and there's no indication here that there's documentation. So you are definitely on the right track there. Some things that are in here that hopefully made you cringe a little bit when I read this was fresh ideas. She does not get it and partnered up with old school. So all of those things together, and maybe individually not so bad, but when you look at the whole picture, these things could absolutely result in age discrimination, Dr. Smith, if you don't have that documentation that you're talking about, right? So very, very good perception of what not to do in this scenario. All right, let's go on to our next one here. This is Billy. And just so you know, these names are all my neighbors. So when I do these scenarios, this is so if there's a name that's one of you, it's not you, these are all my lovely neighbors. So they are unwilling participants in my training scenario. So Billy is a newer employee with ABC Company. Still within his first year of employment, he is catching on pretty well in his role as a marketing strategist with a few bumps along the way, but no real concerning issues, except he does tend to miss more work than the rest of the team. He's not eligible for FMLA yet, right? We all know you got to be there a year and work so many hours before you can take FMLA. So his supervisor, Mary, she's not let HR know this. She's just kind of taken a mental note about this. As time goes on, his absences, they do remain consistent. Mary is concerned about having major issue once Billy is eligible for FMLA. She's like, man, if he's missing this much work now, can you imagine what happens when HR gets their hands on this? She has a reason to believe that the absences are medically related, but she's not asking any questions. She's been down this road before with those pesky HR people and is intentionally keeping her concerns about his absences quiet for now. Since they are working in an at-will state, Mary wants to proceed with termination before Billy is eligible for FMLA. What are we thinking about this one? Any takers? What red flags are we seeing here? All right, Julie, you're up.
I would say that she should have documented that earlier on and definitely needs to start now.
You got that right. Documentation, it's our best friend. Is there anything else in here that you think, I mean, aside from the very obvious intentionally keeping HR out of the conversation, I'm not going to be cool with that. But is there anything else in here that you think stands out?
Should she maybe have a conversation with him about it?
Right on. Number one, there are so many instances where supervisors, they don't want to, I get it. You don't want to impede upon people's privacy. And there's this belief that you can't have conversations, but it's okay to look at somebody and say, hey, you're missing a lot of work. Is everything okay? Do we need to call HR? Communicating with people is the number one thing that supervisors don't do or they don't want to do. And that actually winds up biting them in the end. So let's put up my red flags here. The red flags, the number one thing is consistently missing work, even though she's not eligible for FMLA. And Mary must have been through some FMLA training because she knows that. They're still ADA. Y'all know what that is, the Americans with Disabilities Act. That still might qualify and start the accommodation conversation. So the consistent missing of work, definitely, like you said, Julie, it's okay to look at that employee and say, I'm noticing a pattern with your absences. Let's talk about it. And if that conversation goes down the medical side, that's when you say, let's bring in HR. They're going to know what to do. So definitely address the issue of consistently missing work. And Mary has reason to believe that they could be medical. So that in itself, whatever that reason may be, she should definitely include HR with that. And then, of course, intentionally keeping concerns from HR. That's not a good practice in any situation. So here we go. I've got ADA here as a big, if they were to move forward with this termination of Billy and Billy were to come back and say, hey, I gave them reasons to believe that I needed an accommodation and they never engaged in the conversation with me. They never called HR. That could be a violation of his ADA rights. Definitely want to keep HR in the conversation. Now, Camden is our next one. And for those of you who know me, that is my son. So Camden is an employee of ABC Company, and he's been employed for over 2 years. His supervisor, Joe, has never really been impressed with Camden's performance. He would consider him a mediocre employee. He doesn't necessarily go above and beyond unless he's asked to do so. So I think we used to say MDR, minimum daily requirements. Y'all, you know these employees, right? But Joe has pretty much left Camden alone, with the exception of trying to encourage Camden by writing positive feedback in his annual performance reviews. I myself have been guilty of this. It's so much easier to praise and encourage the good behavior and hope that that continues, but then not address the stuff you don't want to talk about, right? So Joe thinks Camden should logically figure out the expectations. It's not rocket science, right? Joe thinks it's common sense. He has determined after 2 years and seeing very little progress, he is going to terminate Camden under the at-will premise. He's just done trying, sick of Camden not showing initiative, and therefore he's just going to say, I just want to let this guy go under at-will. Even though their policies don't mention at-will, Camden should understand that living in South Carolina, it is an at-will state, right? We all know this. So with this scenario, what things are heightening your spidey senses? What are things in here that you're thinking, I don't know about that? Any takers? All right, I'm going to go ahead and jump in, and we're going to go to the next one. Oh, Dr. Smith, you're on.
Well, there were a couple of things that stood out for me. The lack of documentation over the years, over the 2-year period, giving him positive feedback or whatever. If this comes back, then that information can be subpoenaed for a lawsuit. And then just the no mention of the at will can be problematic as well.
Absolutely. You're my documentation person. I can tell, and I love it. So here we go. Lack of clear expectations. Performance reviews were all positive. Like you said, that's going to be the first thing people are going to look at, and they're going to say, let's look at those performance reviews. Well, Camden looks like a stellar employee based upon your own feedback, right? And then again, the no mention of the at will. Y'all, we can't assume that people know things. Common sense is no longer a thing that we can just depend upon. You got to spell it out. Absolutely. And then for this one, it could be discrimination. Now, I kind of told you my son, but you don't know what Camden is, who he is, how old he is, what protected class he may be in. So that's kind of on the table as a possibility. But again, the implied employment by the lack of no at will mentioned in any of the policies or procedures. So that in itself implies employment. All right, we have one more scenario, and then I'm going to skip ahead to the very end so that I've got a couple of references I want to share with you all. But we're going to talk about Shelly. She accepted the position of maintenance coordinator with ABC 2 weeks ago. ABC has a 90-day probation period for all new hires with language in the offer letter that clearly states this understanding. After 90 days, you will be given a permanent position with ABC Company. However, in these first 2 weeks, the supervisor is convinced they made a mistake. Shirley's not a good hire. She's not performing like they want. Supervisor doesn't want to prolong this any further and just wants to terminate under at-will status. I'm going to go ahead and skip ahead. Our red flags after this presentation, I hope this kind of stood out to you. The permanent position language in that 90-day, again, it's so common to have that language, but that in itself implies a permanent position will be given. And again, have the expectations been communicated? So Dr. Smith, I'm sure you picked up on that immediately. Like, is there any documentation that she's not meeting the performance expectations? And here we've got breach of implied contract is going to be my big red flag with this one. So, folks, we are going to skip this last scenario. It's a good one. So if anybody is just itching to know what it was, let me know and I'll send it over to you. But here are some key takeaways. At will is not risk-free. Always document performance issues. Be careful about accidentally giving these implied assurances of continued employment. Review all those handbooks, offer letters, everything. Review it all. Make sure you don't have any language in there that might be risky. Last, definitely not least, consult your very friendly HR folks. And then I have some additional resources up here. I have a couple of links to sites. Again, I know you can't click on this because you guys are watching my presentation, but if you would like to have these, I'm more than happy to share these with you. I also put up a couple of books up here. If anybody is just riveted by this subject and would like to learn more, these are some good resources. But I'm going to end it here with, are there any questions? Is there anything? We've got about a minute left. Is there anything, questions or comments that anybody would like to ask? Yes, I've got, let's see here. I'm going to start with Mr. Perez. I think I've got you unmuted. There we go. Well, I can't hear you quite.
Okay, can you hear me
There
now?
you are. I hear you. Yes, there
Okay.
you are. Hi.
Hi, how are you?
I'm
A
good.
quick
How
question.
are you?
I know,
Yes.
very good, thank you. I know that California, it's at will, but you know, California being California with all the specifics and all that, is there anything or any particular items or things that we need to do for California specifically?
I definitely think that we would need to, my first recommendation was, let's look at your employee handbook. I think that's a very good starting point. And do you have a separate one? Do you have employees all over, or are you just in California?
No, we do have all over. Texas,
Okay,
California,
okay.
New York.
Yeah, okay. Typically, we've got a separate, because like you said, California is California. Typically, there's a very specific employee handbook, but I definitely think if you want to touch base after this, we should begin by looking at that employee handbook and make sure that the language is consistent, not only with what I presented here, but anything that's specific to California.
All right.
So I know that's a very not very concrete answer, but
No,
that's
but
let's
that's
talk
California.
further, right? Yeah, that's
It's in a
California.
different pot. I get it.
I
Thank
get
you.
it. Oh, I totally get it. Yes. Thank you. That's a great question. I thought I saw one other hand raised, and I know we're out of time, but I'd hate to not answer any questions. Okay, well, let me end this with, thank you so much for attending this. This has been recorded, so it should be available to all of you. If you can't find it through the link in your Teams, let me know and I'll get it over to you, and I'll share with anybody that you would like to share it with. So hopefully I will see you again with the next fun topic next month. So definitely sign up for that. And I hope that you all have a fantastic rest of your day. So bye, everybody.
Bye, thank you.
Bye-bye.
Bye,
See
thank you.
ya.